here to talk to you today about a case that has been recently decided in the Northern District of Illinois, which is a Seventh Circuit Federal Court, called Motorola versus Hytera. Now, whether you have just a small, if you're a startup or have 10, 20 employees or much larger organization, I think this case is going to be very significant for many years to come regarding what happens when employees leave an employer, take a bunch of assets with them, go to another business, and that business begins competing with the original employer. So let's talk about this. This is a 2017 case, and the facts are really, pretty similar across the board with what you find in other cases. Motorola had developed front-of-the-line digital technology for its two-way radio products, and they had worked on this, invested millions in research and development. 3 gentlemen in 2008 decided to leave. Motorola had them complete a variety of documents upon their departure, and all 3 left to go to what was then a supplier of Motorola called Hytera Communications. This overseas company merely supplied Motorola's products in Asia. So off they go. It's 2008. By 2010, Hytera is attending meetings and has products to roll out, which seem to be competitive to Motorola's digital two-way radio systems. Motorola smartly, whether this is intentionally or not, waited in the tall grass for them, and by 2017, they brought a lawsuit in federal court suing for violation of Motorola's trade secrets. But they didn't just sue under the Illinois Trade Secret Act, which is one of the uniform trade secret acts across the country to stop employees from taking assets. They sued under this new statute called the Defend Trade Secrets Act. Now, this is a federal statute which allows companies to bring in federal court an action to stop this loss of business. And this is a pretty big deal because in 2018, the U.S. Trade Representative indicated in a statement that U.S. businesses per year lose between $250 to $600 billion annually in revenue from this type of theft. So since really in the 90s, there have been a series of federal cases which have been enacted. Now, the Defend Trade Secret Act, DTSA, was enacted in 2016. This case, Motorola, is one of the first cases to apply that statute. And they can do that because Motorola was selling goods and services, of course, across the United States and across the world. So this applies in cases where a business has interstate commerce and worldwide commerce. Moving forward, the case was heard. It is extensive. I went to check the file, and there are over 978 individual entries in the court history file, which is enormous. That's pleadings, motions, orders, all documents which have been entered into the case file. This is an enormous case. And it's also enormous because the judgment entered in this case was for $764 million for Motorola and against Hytera. What makes this a unique case in particular is of that total damage award, $345 million was awarded as it's called compensatory or economic damages. Under this new statute, the court reasons that they could hear about damages that Motorola had suffered through an expert of worldwide damages. So not just damages in the United States, but all across the globe. This is huge. So that was part of the damages. And then $418 million in damages was awarded to Motorola, which were the punitive damages, which included attorney's fees and just awards for this misconduct that the employees and this company brought against Motorola. This is a huge and significant case. You may say, well, what is a trade secret? And I think that it seems kind of obvious, but it's important. It's an asset of any kind. It can be written, it can be data, it can be communications, which the owner holds as having value to his, her business, to operate the business, in which if that asset is disclosed to a third party, they can then use and that third party can benefit from. So in this case, the employees took over 7,000 separate documents and items and transferred them before they left and brought them with them to Hytera. That's an enormous theft of intellectual property. So off they go. Motorola waited for them and waited for them to start being competitive and then sued. This case went on for 2 years. The jury gave a verdict in February of 2020, and the judge recently upheld that award for this amount of damages. In terms of, the trade secret, it's important that when you have a trade secret, you also have to take reasonable steps. And, this can change from, whether you are, the magazine store on the corner to whether you are making digital high-tech software or products. For your industry, you have to do what is obviously the most reasonable you can. And again, you can imagine in terms of litigation over what is a trade secret, there's just as much dispute over what is a reasonable step. But these are two of the most important components in this area of the law. This case represents an ability for a plaintiff to not only sue for the Defend Trade Secrets Act, but they brought a myriad of other counts and complaints against Hytera. So they used the Defend Trade Secrets Act, and they used the Illinois Trade Secrets Act, as well as some other copyright and other issues that were heard in different cases. I wanted all of you to think about this, because when you have a business, you have to have an action plan. And oftentimes what we see is people come to us with a partnership agreement or a shareholder agreement or an operating agreement, however the business is structured. And it can be prepared by somebody's brother's nephew's third cousin who can crack open Google and download a document, and people edit it and don't really think, well, what happens, right? So what happens when you have this document that is your operating document, and you now have to stand in front of your lawyer and maybe 5 of those lawyers, as well as your opponent, and there could be another 5 on that side, and they start asking you questions. Well, why did you do this? What made you act on this provision? And on and on and on. So you have to think to yourself, is this going to stand up? Do I understand it? Because if you don't understand it, a judge is not going to understand it, and quite frankly isn't be terribly sympathetic to you when you present a document that's incomprehensible. The next part is, when you're operating your business, you again have to ask yourself, what are my trade secrets? And you have to protect them. You have to have a plan, and you have to speak to professionals who can help you organize your information and create a scenario where your employees are made aware of this and are prohibited from downloading and stealing these things when they're going out the door. And no matter what you do, as we know, it doesn't matter because people will do what they're going to do. So then you have to have a clear plan in place. You have to have a security plan, a data protection plan, a privacy plan. All of these things have to be organized, and they may be all the same thing, but the fact of the matter is stamping something confidential does not make a document or a program or a software confidential. There's more required for that. And I think the third thing is that you have to review this. So if you're looking at, if you have been in business for 5 years, 10 years, 15 years, have you gone through and done an analysis, an audit of these records and documents? Are they up to date? Have they kept up with the current thinking? What are the best practices right now versus when you started? Times have changed and requirements have changed. So all of these things have to be done to help keep your business in tip-top shape and able to compete in a very, what is an increasingly small world. Now, for employees, the issue is, well, I'm not happy, I want to leave, I'm starting my own business. Again, you may have signed a restrictive covenant or any other number of other documents, but what's the value of that document today? How does it apply? You need to reach out to somebody, an attorney, and when I say somebody, I mean an attorney, and say, what does this mean for me, and what can I and can I not do? So when a case is brought, typically it's an emergency, and injunctive relief is sought to stop the employee and stop the competitor from taking these assets. It's very expensive, it's very fast, and a defendant in this case, can be left with having to defend against a company who has far more resources than a new startup. So you want to think about these things and be prepared. There's a right way to start a business and a wrong way. And no matter how angry or disaffected you may be from your employer, you really want to take some time and be methodical and thoughtful on how you start your business. Now, for employers, there is a whole host of an arsenal of steps that employers can now take. Today, I wanted to talk to you about the Trade Secret Act, the Defend Trade Secret Act, but there's other acts that can provide additional relief for you, and we will talk about that in subsequent vlogs. For now, I just would like you to take away and think about where are you at in your process of protecting your assets, and what, if anything, needs to be done. If you need help, I certainly can take a look at it, whatever you have, and make some recommendations. If you're starting a new business, I'm certainly prepared to provide advice on how you can go about this in the right way. Anyway, have a good day, and thank you very much. I'll see you again very soon.